Ladies and gentlemen, good day or good evening, wherever you may be. Thank you for taking time out to be with us today. My name is Raj Panchmatia, and I'm a partner in Khaitan & Company Dispute Resolution Practice Group. I would like to extend a very warm welcome to you to this webinar, to every one of you, whether you are in our audience in India or around the world. We have more than 45 countries represented amongst those who are registered for this webinar. So our audience today is international one. Our agenda for the webinar today, our objective is to provide our audience with an understanding of the difference between the approach to the arbitration by each of the 4 arbitration institutions represented here today. We ultimately decided that it would be best for the institutions to make their own pitches, and we are delighted when they accepted our invitation to participate. On this slide is the agenda for today's webinar. Next. In summary, we will have a short presentation on the advantages of institutional arbitration and the similarities between different institution systems, and then each of our guests will have the opportunity to address you on the advantages offered by their own institutional approach and rules. Those presentations will be followed by a question and answer session with audience questions. We have already received several audience questions, and if you do have questions, please submit them using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar. Also, please note that a copy of the presentation and the recording of the webinar will be shared with you post the webinar. A short introduction on the topic today. As an Indian law firm, we strongly favor arbitration as a method of dispute resolution. Arbitration is already very popular with Indians as a method of dispute resolution, both domestically and internationally, and we are seeing tremendous growth in arbitration in dispute resolutions involving Indians. Internationally, there are significantly increasing number of companies using international arbitration institutions for dispute resolution. There is a great deal of interest in different arbitration institutions that are available for dispute resolutions, and we thought it's timely to explore those differences in a way that could inform future decision making, and thought that there would be no better way to do this than have the institutions themselves explain what they offer and why. So here we are. In this webinar, we are entirely neutral and leave it to the institutions' representatives to make their own cases. It's up to you to decide which institution arbitration rules you prefer. We have already shared the profiles of all our speakers in advance. Just briefly, I would say that we are very fortunate to have an esteemed panel of very senior executives from leading global arbitration institutions, namely Alexandra Fessis, Secretary General of International Chamber of Commerce, Jamie Harrison, Deputy Director of London Court of International Arbitration, Kevin Nash, Registrar of Singapore International Arbitration Centre, Niti Sachdeva, Secretary General of Mumbai Centre of International Arbitration. It is difficult to think of a better expert panel to discuss this topic. In addition, we are joined by my fellow partner, Kingshuk Banerjee from Khaitan & Company, who is an experienced arbitration lawyer himself. To commence the proceedings and to provide some context for the individual institutional presentations, I would now like to ask Kingshuk Banerjee to deliver his presentation on institutional arbitration and the similarities between the institutional rules. Over to you, Kingshuk.
Thank you, Raj. It's truly a pleasure to be here, and this is an exciting webinar. And as you mentioned, we have a stellar lineup of speakers. And given that I'm as eager as all my audience members to listen to them and their insights, I'm going to keep my piece very brief. I do have a comparatively easier task today. I am required to let you know what the advantages of institutional arbitration are as compared to my panelists and fellow speakers, which is the exciting section, and we'll move to that very shortly. But as I said, my presentation is about the advantages of institutional arbitration very briefly, and in that context, I will also touch upon a few tools that feature in most institutional arbitrations, which really make institutional arbitration a very attractive proposition. We can move to the next slide, please. Yeah, next slide. Next one. So on your screen, you have a few reasons why I believe institutional arbitration is preferable. Of course, there are several reasons, but we'll restrict this to 5 key points, and this is my personal view. Firstly, one is able to predict timelines and costs very easily. I think that's a huge advantage in institutional arbitration. The process of an institutional arbitration is clear. There's no uncertainty. There is a defined framework within which the arbitration is conducted. The administration of the arbitration by the institution increases efficiency. I think that is a huge advantage when you compare it with an ad hoc process, which is really a process which is conducted in that sense by the tribunal and the parties. The administrative assistance that you receive from institutions is invaluable. Tribunal formation is quicker. Again, in the Indian context, this is a standout feature. Those familiar with the appointment process in ad hoc arbitrations in India will vouch for this feature in institutional arbitrations. And finally, I do believe that arbitrators are more accountable to institutions, and this inevitably improves the quality of awards. The benefits of institutional arbitration was noted by our lawmakers who in 2019 introduced some amendments in the Arbitration and Conciliation Act, which clearly encourage institutional arbitration. Unfortunately, we are still waiting for these amendments to be implemented, and COVID, of course, has not helped. But the intent is very, very clear. Moving on to some specific tools and provisions that make institutional arbitration attractive. Again, because we are all very eager to listen to our co-panelists, we'll keep I'll restrict my bit only to 4 or 5 tools, which I think are also common and featured in all of the major rules. To begin with, as I already mentioned, one of the key reasons I would choose institutional arbitration is to ensure a speedy constitution of the arbitral tribunal. Institutional arbitration makes this possible with very robust provisions. And as I said earlier, appointment of arbitrators in an ad hoc process can be very time consuming, and that's just not the case when you pick any one of these rules that we are talking about today. Next, another very interesting and important provision is, sorry, can we go to the next slide, please? That's right. I'll come back to joinder of parties in a bit, but the other important provision that is available and that is there in most, if not all, major institutional rules is the ability to challenge the appointment of an arbitrator. And while there are different grounds that each institution provides for, but the one common ground is if circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. Now, this is a provision that also exists in our Arbitration and Conciliation Act, in the Domestic Arbitration Act, Indian Act. But the institutional rules very helpfully define the process of challenge and lay down the broad contours on when and how this remedy can be exercised. I think that's one key difference. And the other difference, of course, is that the challenge is determined in the case of an institutional arbitration by the court or the secretariat or the council, which is a third party under the rules, as opposed to the arbitrator himself or herself in an ad hoc arbitration. So that's one key distinguishing feature that's there in the rules. Next slide, please. Now, expedited procedure is, of course, another very, very important feature. There was a recent survey that was conducted by Queen's Mary, and when asked what features make arbitral institutions more attractive, more than 25% of the respondents chose the provision of expedited procedure. And what is expedited procedure? In summary, it allows institutions to shorten certain time limits, such as the time available to constitute the tribunal, hold a case management conference, or to render an award. Now, a very, very important tool to manage time and cost in international arbitration. Again, a common feature amongst all major institutional rules. Yeah, we can move on to the next one, please. Interim relief, we are all aware that all major rules contain provisions on interim reliefs, but a more recent addition in the last decade perhaps is the ability to apply for emergency interim reliefs even prior to the appointment of arbitrators. Different institutions have adopted emergency arbitration rules at different points of time, but I think now it's a common feature. While there are some teething issues in India on enforcement of emergency orders, especially if the tribunal is seated outside India, but it's still a very helpful tool to obtain urgent interim measures, especially when the tribunal is not constituted. Now, a couple of other features, I think consolidation and joinder of parties. We saw the slide on joinder very briefly, but consolidation of arbitration, it allows parties to consolidate multiple arbitrations. Again, I think a standout feature in institutional arbitration, especially given the complexity of transactions today. You don't have a situation where there's one contract that's in dispute. You have very complex transactions, multi-party contracts, multi-transaction, multi-document contracts, and therefore provisions like consolidation, joinder of third parties, again, are very, very important. Of course, you have to read the fine print in each rule to see how and when those provisions apply. And each institution, they have their nuances, but again, standout feature. And I think with that, I will conclude my short presentation and hand the baton back to Raj, and looking forward to hear all the panelists' exciting next hour. Thank you.
Thank you, Kingshuk, and I may say very insightful. Thank you. We will now move on to the presentations from the institutions. Each speaker would have a minimum of 10 minutes and maximum of 15 minutes on their presentation. We will start right up with Alexander Fesses from ICC, Secretary General of ICC. Over to you, Alex.
Thanks very much, Raj, and also thanks to Kingshuk for his very insightful presentation on similarities on the different institutional settings. I'm very pleased to be here, sharing additional insights on what the ICC does, and sharing the floor, of course, with my esteemed colleagues from other institutions as well. Over the next few minutes, and given that we have been asked to focus on the elements that each institutional setting makes it rather unique, I would like to speak a little bit with regard to the value proposition of the International Chamber of Commerce, the ICC, and more specifically, of course, for the work that we do with regard to disputes, and that is arbitration and other ADR, in the context of the department that I have the pleasure of heading, which is the ICC Dispute Resolution Services Department. So if we can move to the next slide, a couple of things, first of all, on the ICC. The International Chamber of Commerce was formed in the immediate aftermath of the First World War. And the reason and its guiding philosophy for being formed at that time was quite simple. The atrocities of the First World War should never repeat themselves again. And one way of making sure that that will not happen again is to promote international trade. By promoting international trade, we contribute to world economic growth. By contributing to world economic growth, we lead to prosperity of nations. And by making nations prosperous, we aim and achieve, hopefully, to embed global peace. Now, things may or may not have gone that way over the next 100 years, but that guiding philosophy still very much applies to the work that we do in making sure that business works for the 45 million companies that are currently members of the International Chamber of Commerce. What we do is to promote international trade, responsible business conduct, global regulation, and importantly, for you and for us, dispute resolution. and we want to make sure that the voices of businesses are heard. Over to the next slide, please. Could we move to the next slide, please? Maybe the one right before. Thank you. A few words with regard to our mission and our purpose. We are here to make business work for everyone, every day and everywhere. And much as this may not seem to be very disputes-oriented, dear colleagues and friends, I stress these points because this is part of the unique proposition of the ICC in disputes as well. We excel in what we do, or we consider that we do, because we actually understand the way that businesses operate and we understand their needs. And obviously, our ability to assist them in resolving their disputes goes into understanding what their needs are in the context of the commercial transactions that they engage in the way that they interact within their own jurisdictions and across different regions, and indeed internationally. And we are therefore present to enable them in order to secure peace and prosperity and security for all. Next slide, please. And in the context of what we do, which is particularly with regard to the first two prongs of that, which is to grow the economy and revive global trade, which is particularly important in light of the peculiar circumstances that we've all been experiencing over the past 20 or 21 months. There are a number of action points that speak squarely to the global business community outside the context of disputes, but also in the context of disputes. And one of the ways that we achieve those goals is to maintain a world-leading private dispute resolution system. And this is basically where the ICC courts and the Icc arbitration rules come into full play. Next slide, please. That's us, highlighted. Next slide. Thank you. So why choose the Icc rules? I will not go, given that Kingshuk actually already laid out a point which I think my other colleagues will also agree on, that it's sometimes not necessarily the institutional setting itself, the procedural setting, or the words used in the rules themselves that contrast one institutional offering from the other, but perhaps the way that that offering is presented to the parties from one institution or the next. I really will not focus so much on specific features of the rules, but on more broad reasons why the Icc rules are unique and why they work for businesses worldwide. Next slide, please. The first one is the fact that Icc is a truly international institution. You may click on the slide, given that it's animated. First of all, to really explain how I in Icc stands for international, we have in 2020 alone, we had 2,500 parties using the Icc arbitration rules, and they came from 145 countries from around the world, including India. At the end of the year last year, we had more than 2,000 pending cases. The number is still more or less the same today. And those cases are conducted in 12 different languages, all on the basis of party choice. Icc arbitration can be used and is in fact used to resolve disputes arising out of all economic sectors and different industries, notably energy, infrastructure and engineering, telecommunication, pharma, travel and leisure, banking and finance, distribution and agency agreements. If we can move to if you can maybe click again, our tribunals are constituted by arbitrators who come from a variety of nationalities and different legal backgrounds. 92 different nationalities last year, with more than 1,000 arbitrators sitting in more than 113 cities in 65 countries. Much as all of this is international, our clients who use the Icc arbitration rules also use them in the context of domestic transactions. In fact, 31% of disputes arose in the context of contracts concluded rather by parties who were active in that same jurisdictions, or were nationals, if you like, of a single jurisdiction. So the I stands for international in a very global and all-encompassing way. It includes international, regional, and domestic. Next click. Claims, importantly, are also show a very interesting variety. We have about 14% of our cases that are below 1 million. And this really speaks to the strengths that Kingshuk mentioned with regard to expedited arbitration, which is used a lot for cases below 1 million and more recently for cases below 3 million. The average amount in dispute of claims is about 145 million last year, yet the median is much lower, 10 million. And again, that actually shows the full gamut or the spectrum of complexity and size of claims that come before Icc arbitrators for resolution under the Icc rules. The overall amount in dispute of cases administered last year was in excess of 259 billion US dollars. So again, a truly global, international institution that understands the needs of businesses and understands arbitration, not on the basis of the premises of one legal system, but of all legal systems, not on the premises of political interest, but on the basis of neutrality of all systems and all players who come into an arbitration in order to resolve their disputes and continue to conduct business. There is no policy with regard under the Icc rules with regard to favoring one jurisdiction over the next. It is precisely that defines the internationality of the work, of the way that we do our work, and the way that we approach disputes as well. Next slide, please. Service excellence from start to finish is the second reason. We are known for what is known as a hands-on approach to case management. That does not mean an interventionist approach. That means active case management in all stages of the proceeding. Parties that use Icc arbitration pay a service fee to the Icc Secretariat in order to ensure that their disputes are managed well. And that money is being put forward to a very good service. We are there to assist parties, to assist arbitrators, to assist tribunal secretaries in making sure that they meet their obligations and their expectations under the Icc rules. To do that, we interact daily with all of them, with more than 115, 120 staff members today, legally trained, who come from diverse legal backgrounds, including Indian nationals working in Singapore currently and administering cases involving Indian parties. We have 12 case management teams taking care of those 2,000 cases that are currently pending, and they are stationed in different offices of the Secretariat in many parts of the world. Here in Paris, in Abu Dhabi, in Hong Kong, in New York, in Sao Paulo, and in Singapore. Next slide, please. The Icc rules provide, apart from all the points that very helpfully Kingshuk has listed for you, a number of signature services. And those there is one which no other institution provides, and that is Icc Scrutiny of Awards. Icc Scrutiny is an exercise in quality, in validity, and in the enforceability of an arbitral award. It is, as I said, a process that no other institution provides. It is fully acknowledged in the Icc rules. It is acknowledged in legal doctrine, and it is acknowledged as such in international case law, including Indian cases. Can I please ask you to make one more click? Thank you. As I said, it's an exercise of validity and enforceability and quality of the award. The Icc court, which currently has an Indian vice president, a colleague of Raj and Kingshuk, our good friend Sanjeev Kapoor, together with Pallavi Shroff and Kunal Vahani, and about 193 other experts in arbitration coming from a variety of jurisdictions from all around the world, receive Icc draft awards prior to their notification to the parties, and provide, and they instill their expertise and their knowledge with regard to how to make an arbitral award enforceable at law, and how to basically increase its quality so that parties can understand that tribunals have well digested the issues to be determined and have well reasoned their awards in order to communicate with clarity why they decided the way that they have. And again, this is not a service that another institution provides. This happens day in, day out with every single draft award that ultimately is rendered under the Icc rules. In 2020 alone, 564 awards were approved through that process. Very quickly to the next slide, please. Predictability of costs. Tribunal fees and the Icc administrative fee can be calculated, and are calculated, in fact, on the basis of the amount in dispute, the so-called ad valorem system. That system provides predictability because parties can actually forecast those expenses on the basis of a freely available software on the Icc website. So before you start a case, you can actually consider what the budget for tribunal fees and the institutional fee will be in that regard. And usually that budget will not increase by more than 1 to 2% for the service that you will be getting under the Icc rules. Importantly, the Icc court oversees the financial aspect of each case, and there is no room for separate fee arrangements, and therefore that predictability is basically solidified by the work that the court does. Next slide, please. Transparency. Parties use Icc arbitration because they can actually have access to all elements, to many elements that explain to them how arbitration works and how it works specifically under the Icc rules. If you're looking to appoint or designate arbitrators in your cases, you can actually see real-time who are the arbitrators who are sitting in pending and in concluded Icc arbitrations. You have that information available to you free of charge. Similarly, you have access to Icc awards, awards rendered under the Icc rules that indicate how tribunals decide different commercial disputes and how they do so under the rules themselves. And again, that is offered to you free of charge. In the context of the Icc rules, parties have the discretion to request the Icc court to provide reasons for certain decisions that it takes, including notably challenges against members of the arbitral tribunal. Those decisions are handed down with reasons communicated to parties and tribunals, and ultimately, once sanitized, they are published to the public at large, again, free of charge. And this is something coming in 2022. And lastly, and very quickly, as I'm already 13 seconds above my time, Icc is the world's #1 arbitral institution. For many years now, the leading industry surveys which are basically to which clients, the users of arbitration and arbitrators, contribute their feedback, designate Icc as the world's most preferred arbitral institution. And that happens not just because of service excellence and the other 5 reasons that I have already enumerated here for you today. It is also because we are champions in thought leadership and in training and in publications. We wish to further our common understanding with regard to how disputes work in arbitration and in ADR. We want to develop further the doctrinal, legal foundations of arbitration and ADR law, and ultimately we want to disseminate all the information to the widest possible public as far and wide as we can. I hope that this illustrates why the Icc value proposition under the rules is unique, and I'm very happy to take any questions should there be any. Thank you all very much.
Thank you, Alexander. That was a great insight into the Icc. May I now request Jamie to give us his presentation on LCIA. Jamie.
Thank you. Thank you, Raj. I'd like to thank Raj, who's been a friend for many years, for his kind invitation to join this panel, and to Ketan, whose very generous hospitality I've taken far too often over a number of years. And it's a great pleasure to be here. I regard this as a form of institutional speed dating, and I make no apologies for unashamedly promoting the best interests of the LCIA. Of course, in doing that, I should say that I do respect my fellow panelists and, of course, the institutions that they represent. However, I make no apologies, of course, for putting forward the best of the LCIA. If we could have our first slide. Just three very short points, which will give you an overview of why we say there are distinct benefits for choosing the LCIA as the administrator of your dispute. We have an international and diverse caseload. Although I'm afraid we can't claim to be pivotal to the security of global peace and prosperity, we are one of the oldest institutions in the world. We're established in London, which many regard as the cradle of modern international arbitration, and we have a track record of cases across many different industries and jurisdictions. In 2020, we had an all-time high of 444 referrals, of which 407 were pursuant to the LCIA rules. And of course, we also have mediation rules and offer other ADR services. Our acknowledged speciality has to be in English law cases, but we do administer many cases seated in London and or with English governing law, but also we administer many cases that are not seated in London and don't have English governing law. For instance, in 2020, there was a marked increase in non-UK seats and choices of law. We also administer arbitrations from parties across the world. In 2020, 86% of parties in arbitrations administered pursuant to the LCIA rules were from countries other than the UK, 86%. And in 2020, 9.2% of those parties were from Asia. The LCIA rules are used in arbitrations that deal with many different types of disputes. We administer arbitrations involving sale of goods, service agreements, shareholders agreements, share purchases, joint ventures, loans, and other financial instruments. We administer cases across different industry sectors. In 2020, energy and resources, transport and commodities, banking and finance accounted for 68% of all arbitrations pursuant to the LCIA rules. We also have a diverse pool of arbitrators. We maintain a database of potential arbitrators, including information about their language skills, legal and industry experience. And the best and most suited person for each dispute is selected. The LCIA court appoints arbitrators who are qualified in common law jurisdictions and civil law jurisdictions and speak many languages. Parties often choose the LCIA for the appointment of British arbitrators. However, in 2020, for instance, in arbitrations administered by the LCIA, there were appointments of arbitrators from 40 different countries other than the UK. The LCIA is also considered to be a leader in gender diversity. With respect to arbitral appointments in 2020, 33%, that's 175 out of 533 of arbitrator appointments pursuant to the LCIA rules were female. The LCIA is also known for its streamlined and efficient arbitration process, which I hope will be reflected in my ability to make this presentation within the allotted time period. The LCIA rules are tried and tested, and the new 2020 rules were intended as a light touch update with really considerations of efficiency in mind. In other words, our new rules emphasize the streamlined and efficient arbitration process that the LCIA rules offer. For instance, Article 14.6 sets out from the outset the tribunal's powers with respect to expediting procedures in the arbitration, including the limitation of the length of written statements, employing technology, and exercising newly stated powers to order early determination. The new rules also include provisions in relation to electronic filing of requests and responses, and the issue and signing of awards electronically, and explicit provisions in relation to virtual hearings. So if I could have the next slide, please. Having told you what we would regard as the benefits of choosing the LCIA, we were also asked to highlight a few key differences between us and the other institutions that you have before you. The first thing I wanted to talk about was comprehensive rules. That's not to disparage the other rules, to suggest that there are bits missing. I think what we really want to emphasize is that we only have a single set of rules. The LCIA does not have a separate, for example, a separate expedited procedure based perhaps on the value or complexity of the dispute. We don't consider that that is necessary, given that the LCIA process is already streamlined and efficient, and typically the LCIA administers cases faster than other institutions. On average, from the registration of a case through to a final hearing, an LCIA case takes 11 months. This is extremely competitive, and we would say negates the need for a special process to ensure swift resolution of perhaps smaller disputes or lower value, less complex disputes. In addition, Article 1510 provides that the tribunal should make its final award as soon as reasonably possible and endeavour to do so within 3 months following the last submission of the parties. We also have several provisions built into the LCIA rules to ensure sufficiency. I mentioned the newly stated power in Article 2218 of early determination, and we also have rules at Article 9A and 9B providing for expedited formation of the tribunal and for the appointment of emergency arbitrators. So you get everything under one umbrella with the LCIA rules. You don't need to deviate into special rules or measures. We also have an express provision on compliance at Article 24A, an explicit statement of the circumstances in which the LCIA can refuse to take your case. And we also address data protection and information security in Article 30A. Like the others, we provide for consolidation and concurrent hearings in a wider set of circumstances and at an earlier stage than perhaps was available to users of the LCIA before. And we also have comprehensive rules in relation to confidentiality. In particular, the rules at Article 30 make clear that the undertaking confidentiality extends to any authorised representative, witness of fact, expert or service provider, and to the tribunal and any tribunal secretary. We have a light touch, we would say, in our rules. However, they are comprehensive. Costs is a significant differentiator for us. The LCIA charges on a time basis, which is set out and published in the schedule of costs. A maximum hourly rate of arbitrators is £500 under the 2020 rules, and the fees are calculated by reference to time spent and rates appropriate to the circumstances of the case. The LCIA's schedule of costs allows parties to know how much the arbitration will cost per hour, and the position is safeguarded by the activity of the LCIA court, who verify bills, and the parties are asked to keep the LCIA in funds by request for payment at measured stages during the arbitration. We have no provisions in our rules in relation to third-party funding. Some institutions do, others don't. We have chosen very clearly not to provide for third-party funding. Again, we have a light touch, and we expect that to be something that is resolved between the parties and the tribunal. The reference to confidentiality and third-party service providers is about as close to third-party funding as you get in the LCIA rules, but we have chosen particularly not to deal with third-party funding, not least because we think it's very early stages for that industry, and also we think there are issues over definition. The constitution of the tribunal. Parties and co-arbitrators nominate arbitrators in LCIA proceedings, and the LCIA court appoints them. If the parties appoint, the LCIA court takes this into consideration, but absent a nomination, the LCIA court will appoint your arbitrator. And even with a nomination, it is still the court that appoints arbitrators. The LCIA doesn't vet arbitrators at the outset, takes an open-minded approach and encourages CVs from anybody. LCIA has a pool of arbitrators, but does not limit that to a list or to a panel. To end on a negative, I'm going to tell you about two things we don't do, which we would say are virtues, not least because it makes our process more streamlined and more efficient. Firstly, we don't require terms of reference at the outset. We believe that means the case can get underway quicker than it would do under rules that require terms of reference. We also think that there are problems around the comprehensive nature of terms of reference and disputes that arise in relation to those, which can divert the parties from the underlying dispute. And we don't scrutinise awards in the way that Alex described the ICC doing so. Again, that is about relying on the integrity of the arbitrators who've heard the evidence, who've dealt with the case, and who've prepared the award, and should, we believe, be in a position to deliver it direct to the parties. Again, part of streamlining of our processing and delivering on the awards as quickly as possible. We would say both of those measures make us quicker and more streamlined, and are a clear, as I say, a clear differentiator. That was a scamper through the key differences and the benefits of LCIA arbitration. Like Alex, I'd be very happy to receive comments or questions today or offline, as you can see on your screen. Thank you.
Thank you, Jamie, for the helpful summary on the LCIA approach. I will now request Kevin Nash to give us how the SIAC looks at it. Kevin.
Thanks, Raj. It's great to see you, and it's great to be here with all of my institutional colleagues. I will start off by being a representative of institutional arbitration, and I think the point made in the earlier presentation is very apt. I think by and large, institutional arbitration is now the preferred way of resolving cross-border disputes. Certainly, there are spaces and areas where ad hoc arbitration will work well, but generally, particularly with institutions that have fixed fees and maximum fees, you do get that predictability that was discussed. And if you have a maximum fee for an arbitrator, that arbitrator has to manage the proceedings in order to get it done in a space of time that works for the remuneration. So starting from that premise, I would say that all four of these institutions, very good institutions, modern sets of rules, and I admire each of them in their own right. From an SIAC perspective, we are a global institution, but it really starts with Singapore. And as you're clicking through the slides, I think you're going to have to click many times to get all of the information up. So we are a global institution that just happens to be located in Singapore. Compared to ICC and LCIA, we're a very young institution. We started operations in 1991, so we're in our 30th year of operation, and we had 2 cases in our first year. And that 2 cases has really defined our approach to case management. So even during my decade at SIAC, I've seen the caseload go up into the many hundreds and even over 1,000 last year. And so to take the position that we had at the outset of providing customized case management, of being accessible, that's what we've tried to do as we get bigger and bigger. And when I think about our experience with Indian parties, when you see the hundreds of Indian parties that are selecting SIAC every year, we've really grown in connection with the growth and prominence of India as an arbitral jurisdiction. So even before the Supreme Court provided very helpful clarification on 2 Indian parties choosing a foreign seat, we had fully Indian disputes with Singapore as a seat of arbitration. We will have a panel of arbitrators where all 3 arbitrators might be Indian arbitrators. You can have the venue in India. India law, of course, to the substance of the dispute with 2 Indian parties is going to apply in any event. And now that we're in COVID-19 and most of the hearings are being conducted virtually, it's very easy for Indian parties or parties from anywhere in the world to be able to participate in SIAC arbitrations. And this is a very good thing for the practice of arbitration. Now, assuming that parties choose Singapore, and they do choose Singapore in most of the SIAC arbitrations, I should say, as Alex mentioned, that ICC has a very robust case management office in Singapore. We also have the Permanent Court of Arbitration, WIPO, Singapore Chamber of Maritime Arbitration, ICDR, all administering cases out of Singapore. And parties are choosing Singapore because it's the idea that the rule of law will be applied without fear or favor. Now that's a nice holding from a Singapore court decision, but what I would say in our experience with parties, and particularly Indian parties, is that arbitrations in Singapore just work. And that's what you want to have as an institution. The job of the institution is to make the arbitration proceed more expeditiously. So when I'm discussing provisions of the rules, it's all to hold faithful to the fundamental principles of arbitration. In arbitration, you are supposed to get quick justice. It should be fast, cost-effective, efficient, choose your decider, limited avenues of appeal, confidentiality, enforceability. These are all the reasons that you're choosing arbitration. And with all these different sets of rules, whether they converge or diverge, it is with these principles in mind. So I was scanning back over my past decade of cases, and I came up with a few case management examples involving Indian parties. And that's ultimately what matters, the case management experience. So I can think of an application for the appointment of an emergency arbitrator. And of course, as anyone in our Indian audience would know, we now have a quartet of decisions from SIAC arbitrations involving emergency arbitration. HSBC, Raffles Design, Hotel Mumbai, and now Amazon. So we had an application for the appointment of an emergency arbitrator, but the reliefs requested also went to a non-signatory. So what we had to do in very quick succession is that the party applied for the joinder of this additional non-signatory party. So then rather than having to start separate arbitrations, they applied for joinder. So we had an accelerated schedule for the parties to provide comments, and then we were able to join this non-signatory pre-constitution. Then an emergency arbitrator was appointed in respect of the now claimant and respondent and additional party. I can also think in one of those emergency arbitrations that ended up going to India of an emergency arbitrator having the hearing that went very deep into the night. This hearing was attended by SIAC counsel. The emergency arbitrator provided her order in the middle of the night. The SIAC secretary then was scrutinizing the award, and we were able to turn it around overnight. And then I suppose one of the advantages of SIAC is our flexibility in that we're quite nimble. So we also had a case with an Indian party involved where the parties had selected in the clause that the award had to be rendered 120 days from the constitution of the tribunal. I should say I've also seen arbitration clauses where the parties have provided as short of a time as 14 days from the constitution of the tribunal. In this 120-day clause, we received the draft award for scrutiny from the arbitrator on day 119, despite our reminders. We were able to scrutinize that award, turn it around to the tribunal, and then the award was issued before the 120-day guillotine. Had we not been able to turn that around because the parties had agreed to it in the arbitration clause, then the award would have been vulnerable on the basis that the arbitral procedure was not in accordance with the agreement of the parties. So the takeaway from an SIAC arbitration, as hopefully many of you would know, is that we're still faithful to our user-friendly approach from when we are a very small regional institution, and we're very nimble and agile in terms of the way that we can run the case management. If you proceed to the next slide, you can see our users of SIAC arbitration. Year on year, as I mentioned, Indian parties are very frequently choosing SIAC arbitration. And if you look at the top trading partners of India, many of India's top trading partners are also top users of Indian arbitration. And you can see that we also have a good divide between common law jurisdictions and civil law jurisdictions. We had parties from 60 jurisdictions in 2020, and in the last 5 years, we've had parties from more than 100 jurisdictions. On the next slide, you can see our categories of disputes. 2020, because of the COVID-19 pandemic, was a bit sui generis in terms of the overall spread of our caseload. You can see a lot of international trade, a bit less in terms of construction and engineering and major projects. Maritime and shipping is always a big contributor of our caseload. Singapore is the second largest container port in the world, but we do have a wide variety of disputes and of course from parties from many jurisdictions. On the next slide, and I've pre-gamed it a bit in terms of the scrutiny process, and certainly we look with great admiration to the Icc scrutiny process. And from an institutional standpoint, when we look at SIAC's value add, the scrutiny of awards is one of the most important things that we do. And I'm sure, as Alex could say, and even Niti with their scrutiny process as well, you will see awards that may otherwise be unenforceable. Now, the tension is how long is the scrutiny process going to take? So depending on the length and complexity of the award, generally we are turning around these awards in a few weeks, but we do have the flexibility to make it much quicker. And for any arbitrators in attendance, I think that they can certainly attest to the substantive nature of the SIAC scrutiny process. So a bit different than the Icc, we have a two-stage process whereby counsel on the case does the first cut of the scrutiny. This counsel would be up to date on the pleadings, attending the hearing, and then it would go to me for approval. And the language is similar in the MCIA rules. Effectively, what the registrar has charge over is the form, but it can also draw the tribunal's attention to points of substance. So the way that actually works, if you saw a tribunal say within the arbitration agreement, the parties had agreed that the losing party is to bear the costs, and you had a claimant that was substantially successful in all of its claims. We might note for the tribunal that the transnational tradition is the cost follow the event. But if the tribunal wants each side to bear their own costs, that's within the tribunal's purview. So we're not there to change the tribunal's mind. We're there to make sure that the award is enforceable, anticipating the potential places of enforcement. Looking at the next slide, and very quickly, you can see all of these time and cost saving measures that have been introduced in the SIAC rules and other leading sets of institutional rules. So emergency arbitration has been discussed. The advantage in the Singapore regime is that emergency arbitrator orders and awards are enforceable as though they're an order of the High Court in Singapore seated arbitrations, and also enforceable in Singapore for foreign seated arbitrations. Expedited procedure, every institution does it a bit different. The SIAC rules track with the MCIA rules to a certain degree, and this is the idea that you can have an award 6 months from the constitution of the tribunal. Very popular procedure under the SIAC rules, and really one of those features that has defined SIAC as a very fast and cost-effective institution. Early dismissals of claims and defenses has been particularly helpful for us during the COVID-19 pandemic, because a lot of our disputes in 2020, there was no issue of whether there was non-performance. You may have had a responding party that says, yeah, we didn't perform the contract, but we were under a national lockdown. And now the question becomes on the contours and parameters of the force majeure clause. Consolidation and joinder is important. Every institution does it a bit different, but the overall idea is the same. Being able to collapse multiple disputes arising out of multiple contracts into one arbitration proceeding. Joinder as well, whether by agreement, non-signatories. Our language for joinder is prima facie bound. So whether or not we're looking to plural controls, it depends a bit on the jurisdiction. Those doctrines to bind a non-signatory is important. And finally, I would close with our ARB-Med-ARB protocol that we have in conjunction with the Singapore International Mediation Center. For us being an institution where our priority is to resolve disputes, we are seeing more and more tiered clauses where parties might first go to mediation or start in arbitration, go to mediation. If they can get to a mediated agreement, then go back to a standing tribunal and have it put into a consent award. But as I said, our primary purpose is to make sure that parties resolve their dispute. So whether or not parties file a notice of arbitration, engage in mediation, or it goes to the final award, we are there to resolve the dispute. And we are certainly very pleased to be amongst our institutional colleagues, and certainly also very pleased with the support that we've had from Indian parties. Thanks, Raj.
Thank you, Kevin. A great presentation and a very interesting perspective about SIAC. I will now request Niti to give us a presentation on MCIA. I know, Niti, you're not doing the presentation, but it's over to you now.
Thank you so much, Raj, and hello everybody. And I think I'm delighted to be a part of this panel where I have an opportunity to hear my colleagues, institutional colleagues, about all the offerings that the other institutions have. I think I'm also glad for the fact that we are the youngest institution on the panel. And when I say young, and I'm sure all of you would agree, the words which come to your mind is new energy, fresh ideas, and enthusiasm. And that is what I would say that MCIA represents, which is enthusiasm, effective dispute resolution, and a zeal to achieve this and much more. I would agree with the thing that Alexis talked about, the advantage ICC has with scrutiny, which Kevin also spoke about with SIAC and MCIA has it as well. Jamie spoke about not having any terms of reference because we want the process to run quicker and faster. MCIA doesn't have any terms of reference either. Kevin spoke about flexibility, and I would say that MCIA as flexible as SIAC would have it. So as you heard my colleagues talk about all the advantages that the institutions have, I would say we being the youngest took the advantage of incorporating the best practices and moving forward from there. I will still try and tell you that why you should choose MCIA. In the next few minutes that I have, I've divided the presentation into three parts of it. One is the rules itself, what is so unique about MCI rules. Second is the organization of the institution itself. And the third is the ease of dispute resolution. Now, the first on the rules itself. Kingshuk very, I would say, eloquently spoke about that how institutional arbitration has the advantages of predictability, certainty, efficiency, appointment, and accountability. I think all my colleagues and you present here would agree that one of the major advantages of having an institutional arbitration is to have the right arbitral tribunal. It's a cliche, but it's true as well that your arbitration is only as good as your arbitrator. And that is what MCIA has in its rules, that though as LCIA rules provide for that the parties can nominate, it's the court/council which appoints. MCIA has a similar provision that the parties can nominate, but the arbitrator is always appointed by the council of MCIA. But we have gone a step further, and there is a very unique twist to the MCIA arbitrations where we provide that for any three-member tribunal, the presiding arbitrator is always appointed by the MCIA council, irrespective of what the clause may provide for, and by agreeing to an MCIA arbitration under Rule 9.4, it is deemed that the parties have agreed that the presiding arbitrator will be appointed by MCIA. And now the question may arise, why so? Though MCIA, of course, is headquartered in India, but we truly are global in that sense, and we would like to call ourselves an international arbitral institution, focus on I rather than the M. But we realize that a lot of parties that we would catering to and the initial years and the caseload would pertain to Indian parties. And we wanted to bring in the whole concept of efficiency, not only in the dispute resolution, but also in constituting your arbitral tribunal. In our experience, we saw that a lot of times both the parties would nominate their arbitrator, but when it came to appointing the presiding arbitrator, there was always a bit of a tough where one party appointed arbitrator would try to appoint an arbitrator whom they were more comfortable with. Now, to bring in that independence, that impartiality, and that neutrality, it was consciously decided and incorporated in the MCI rules that in a three-member tribunal, you will always have the presiding arbitrator of a neutral jurisdiction to be appointed by the MCI Council. The second unique feature that I would say is that as all of you, the users of arbitration would recognize again, that one of the biggest growing concern of the business community with respect to the use of arbitration as a process of dispute resolution has been the increasing cost. To that, I would say MCIA is the solution for this growing concern. The arbitration process is not only effective, but is also cost efficient under the MCIA rules. The administrative fee of the arbitration under the MCIA rules is the least expensive, but still maintaining the efficiency. And when I talk about the difference in the administrative cost, it could be very well in the range of about 26% to as much as 70%, depending upon which institution you're choosing to go for. Moving on from the rules, let me go on to the organization itself. The MCIA Secretariat, which is headed by the Registrar, which I'm glad to be a part of this presentation today. I've had a very unique opportunity, and I would say I've been very lucky to have that I've not only worked in a domestic law firm, and that's why I understand the concerns and the kinds of disputes which the Indian parties come up with. I've also had the experience of working in international law firms, and besides that, I have the advantage of learning from some of the best and older institutions in the world. So I've been a part of LCIA as LCIA India's Deputy Registrar. I had the pleasure of interning with ICC for over 6 months. Though Kevin, I could not work with SIAC, but I have very closely looked in and have friends who have helped us to understand how the administration of disputes goes by. So you have a secretariat and a registrar who has experience of some of the other institutions we've heard from today. And philosophy that we adopt is learn, implement, improvise, and continue to learn, improve, and improvise and implement. Not only the secretariat, but if you look at the council as well, MCIA has a great advantage where probably we're the only institution in the world where our council consists of an ex-president of the ICC, ex-director general of LCIA, and a court member of the SIAC. Again, the point that I want to bring home is that we have the advantage of learning from our older institutions, from our older brothers or sisters, as I would say, and bring in the best practices of how an institution needs to be run, how the rules need to be applied, and to make it more efficient. Another thing that MCIA has always strived to achieve from its very beginning is a very collaborative process. And as Alexis and Kevin and Jamie, actually all of them mentioned, is that one of the distinguishing feature between the institutions is that how we apply and do the case management of it itself. And for that purpose, we have very recently launched something called as the MCIA User Council. And what is so distinct about this User Council is that the focus is not only on any particular jurisdiction, but the focus entirely was on the industry. So these are very industry-specific User Council. And one of the process and one of the advantages that we want to derive from that is that MCIA is now going to enter into its rule revision. And we want to connect with the stakeholders and take it from them as to what kind of rule revision they would expect for a more efficient dispute resolution. So when the rule 1.0 of MCIA was launched about 5 years back, at that time as well, to be as collaborative a process as it could be, we reached out to the maximum number of users across the globe, took their advice, took their comments and implemented them in the rules. And that is what we intend to do when we go into our rule revision 2.0. Let me now come to the third point that I want to talk about, which is the process and the ease of resolving disputes itself. I would say that even before COVID hit us and hit the world and how we started to do virtual hearings, MCIA was leading the initiative to make sure that the hearings were conducted in the virtual format and was considerably successful in doing that as well. But since COVID and earlier this year, what we have done is that we've taken a step forward and we have adopted technology, which is a hybrid plug and play technology. We have entered, which is to make and ease do the whole physical conduct of the arbitration process itself. So even if the parties would like to still go for a physical hearing, we have tied up with WeWork around the globe and within India. All a party needs to do is that locate the nearest WeWork office to them and just call up MCIA offices, and MCIA office will make sure that you have a physical hearing space booked, blocked, every technology arranged for it, for a seamless experience of how to do a physical hearing. Let me just clarify that the reason for doing this technological advancement or thinking of the trigger for this technology was actually the ESG compliant and appreciating the fact that more and more companies now are looking themselves to be ESG compliant. And we want to promote this virtual only arbitration. And as and when the parties do really need to go for a physical space hearing, then they should be able to do it at the least, with the least comfort, and I would say with the most comfort and the least difficulty to travel across the globe. In that initiative as well, MCIA is leading and launching the first of its kind India Climate Change and Environment Disputes Day. And we hope to, lead the initiative in this area to be an institution which respects and wants to contribute towards the ESG compliance. The second thing under the process and the ease of resolving disputes is actually the adoption of technology for the case administration as well. Of course, internally, our cases are managed using the case management tools, but very soon you will see MCIA launching a tool whereby the parties have the flexibility to do everything virtual. And when I say virtual, it is to file your case filing, upload the documents, have your documents hyperlinked, case managed, have your the arbitrator fee be paid online, schedule your hearings as well online with all those facilities provided there. But again, this is not something which will be compulsory. We would want to give parties a freedom that if they would want to go with the traditional way of doing arbitrations, MCIA is always happy to do that. But for the parties who would want to move on to using technology, that is another thing that MCIA brings to the table. Let me just give the last point, which is last but definitely not the least, and in my opinion, one of the most important benefit of choosing MCIA as an arbitral institution would be the India's time zone, and in effect, the time zone within which MCIA operates. Whether it is the waking time of Europe or whether it is the time for Japan to end its working day, India and MCIA are awake to answer any of your calls, to reply to your queries and attend to urgent matters. As parties and users of dispute resolution process, I'm sure many of you would agree that you would not want to wait for a next day to have your answers, questions answered. You would just want to pick up a call, speak to one of my colleagues or myself, and make sure that you're answered well in time. Let me end by saying this, that since I had the great opportunity to have the last presentation, which is in effect to have the last word today, can I safely say this, that I think we already all know which arbitration rules you need to choose, and which is undoubtedly the MCIA. This is with regard to all my colleagues present there. I think every institution has its unique advantages, and it's for the parties to decide which suits best to them for their given dispute. Thank you very much.
Excellent, Niti, and thank you for this presentation. We actually have a lot of questions that have already started coming in, but indeed, thanks to all of you for taking the webinar objective to heart and providing a wonderful insight into each of your institutions and their approach to arbitration. I must also compliment each one of you that each one of you have completed your presentation way before time. So we will take a lot of audience questions because there are quite a few of them. So we'll use that additional time that we have to answer the audience questions now. The first question is, what is the trend when it comes to construction dispute resolution in India? Is it still largely ad hoc, or does the panel think there is a shift towards institutional arbitration? Is there any data in public domain to support this? Niti, would you want to go first?
Sure, happy to do that, Raj. I would say, Raj, in my personal experience, I would say that with MCI now being only 5 years old, we are administering now 35 matters. And I would say that very safely about 50% of our matters have something or the other to do with the construction of the infrastructure industry. So clearly there seems to be a shift of institutional arbitration. If you're speaking about generally within the Indian market as well, though Kingshuk started off by saying that he has a easy task of talking about why institutional arbitration over ad hoc, I think that still remains the biggest challenge in India as to why institutional arbitration over ad hoc. We still have a long distance to cover, but I can definitely say that the shift seems to be there, clearly.
Do any of the other panelists see it differently, or you have a similar views on it? Anyone would want to Anstat?
I think there's a very similar view from London to I'm always hopeful that we will attract more construction infrastructure related disputes to London and to the LCIA, but certainly our push towards greater efficiency, particularly in relation to consolidation and joinder and early determination, I think is a calculated attempt to attract construction disputes to an LCIA platform, particularly well suited to multi-party, multi-contract issues, and obviously, large construction projects tend to be exactly that.
Yeah. So the second question, we'll take the second question now. It's directed to Alexandra. Thank you for introducing the awards features of the Icc and Icc rules. Are awards under Icc rules automatically made public, or do they require the consents of the parties to be released to the public?
Very happy to answer that, and thank you for the question. No, there is obviously no automatic process by which an award is rendered public. The Secretariat is bound by confidentiality, and we obviously honor that to the highest possible level. The way that the publication of awards project works is the following. Wherever the arbitration is confidential, it is automatically excluded from this unless the parties themselves have very explicitly stated that they would like to see their award published. And that does happen sometimes, or excerpts of the awards published, or sanitized excerpts of the award published. In all other cases where the parties have not entered into a specific confidentiality stipulation, given that the Icc rules provide for flexibility to the parties to actually settle on the confidentiality arrangement. So in those cases where one does not exist, the Secretariat will, during the life of the case, inform the parties of the possibility of having the award partly or wholly published. Ultimately, once the award has been rendered, and within a 2-year period after its rendering, if none of the parties objects to us doing so, then the award will be published, or will be published according to those terms that the parties will have settled on. So again, there is no automatic system whereby an award is made public. That would be contrary to the way that arbitration as a mechanism works and what the parties' expectations from that mechanism are, but it does work in parallel to that, to the extent that the parties feel comfortable with it.
Thank you, Elizabeth. There's one more question actually for Icc, and that's it's pertaining to the award scrutiny under the Icc rules. Once the draft award is shared with the Icc and there are certain amendments done to the draft award, are these amendments binding on the arbitrators, or they refuse, or can they refuse to make such changes?
Thank you for that as well, and it's an interesting point. Happy to clarify it. The award is not an award rendered by the Icc courts. It is delivered directly by the arbitrators to the parties under the Icc rules. So the award is always the tribunal's award. What scrutiny aims to do is not to substitute the tribunal's findings or to alter those findings. What the scrutiny process, the Icc scrutiny process at least aims to do, is to ensure that the tribunal will benefit from the expertise of others who have also sat on that chair or who will have pled before tribunals numerous times, to ensure that the award can be understood, can be enforceable and valid. So whatever comment of form the court relays to the tribunal is for its consideration. And any comment that the court may make, which is rather exceptional with regard to substance, will only be raised with full respect to the tribunal's liberty of decision. All of that means that ultimately it is for the tribunal to decide whether to pick up those points for consideration and, of course, to decide on how to address them. But scrutiny is not really an adversarial process. It is actually a process that anyone who has gone through it as an arbitrator or as a member of the Icc court will know is really a system of collaboration between the ICC court and the tribunals, those 1,000 plus arbitrators who sit on ICC tribunals. It is really an exercise in making the award better legally and ultimately as a decision-making document. So it is something that requires and does achieve a perfect level of collaboration between tribunals and the courts.
Thank you, Alexander. Kevin, there's a question for you on the SIAC rules. SIAC Rule 29, Summary Dismissal and Award. How has SIAC's experience has been in this so far since 2016? Has any such awards faced challenges during enforcement? If so, what was the outcome?
Thanks, Raj. I'm going to be a bit indulgent and just return to the construction and major project question just briefly. I think in those types of disputes, more than anything, that's where you want institutional arbitration. The features on multiple contracts and consolidation under these institutional rules are very important for these big ticket major project disputes. In terms of early dismissal, it reminds me a bit of when we introduced emergency arbitration in 2010. In 2016, it became all the rage in arbitration. So leaving to one side that most people would agree the tribunals already had this power inherently to deal with claims that are ripe for determination, our thought process, borrowing from 41 sub 5 of the Icc rules, is that ultimately what you're doing when you're writing awards is you are drafting a letter to the enforcement court. So by codifying this power under the SIAC rules, and we've seen this taken up by the other institutions, whether codified in their rules or by guidance note, we thought that it would give tribunals a bit more courage to deal with claims at an early stage. Of course, ours was an important update from Icc, and not without its challenges, because it's the early dismissal of claims and defenses, and it wasn't captured within that 30-day timeline from the constitution of the tribunal. And I think all of us are aware, if you're saying to a respondent that there's no good defense to this claim, everyone is going to be very cognizant and alive to potential enforceability issues. So there's two reasons I think why it succeeded under the SIAC rules, and it's becoming more and more popular. First, we've made it a two-stage test. So the tribunal first allows whether or not the application is going to proceed. That was the bargain for not making it 30 days from the constitution of the tribunal and to avoid those 11th hour applications on the eve of a hearing. So the tribunal has that power. And the next is the fact that we are scrutinizing these awards. So if the tribunal decides to issue an award, whether it's on the claimant's claim or the respondent's defense, that still has to pass through the SIAC mechanism for scrutiny. The way that it's worked in practice, it does follow a lot of the Icc jurisprudence, whether it's Transglobal Petroleum or otherwise, that unruly horse of the manifest standard. But tribunals are applying that jurisprudence and effectively asking the question, even if we take your facts at their highest, is this claim good or bad in law? And so a very typical case would be a respondent with many heads of counterclaim, and say 15 heads of counterclaim, 10 of those are squarely outside the four corners of the arbitration agreement. So instead of having to deal with these counterclaims all the way through the arbitration, where it may add to time and costs, a party can apply to strike out those heads of counterclaim for manifest lack of jurisdiction. So we're seeing parties get more and more used to it. To me, when I look across all the cases, I think that there is a certain vetting of manifestly unmeritorious claims. You will sometimes see whether it's a respondent in their response to the notice of arbitration, they may raise the specter of an application for early dismissal. So it has really been now a key cog in the SIAC machinery. We've had more than 40 of these applications. And we also, or at least on my part, in UNCITRAL Working Group 2, there was the question of whether you could have early dismissal within the confines of expedited procedure. Because what you want to avoid with early dismissal, same thing as for a preliminary question on jurisdiction, you want to avoid a trial within a trial. The idea is to make things much quicker, and overall, again, because of that two-stage process, our experience has been very good, so it's a useful tool.
Thank you, Kevin. Jamil has a question for LCIA. How will LCIA handle an arbitration clause where parties had agreed to nominate one arbitrator each at their own discretion, given that court nominates the arbitrators?
Sorry, Raj, would you repeat? I missed a bit of that.
Sure. How will LCIA handle an arbitration clause where parties had agreed to nominate one arbitrator each at their own discretion, given that the court nominates the arbitrators?
Do you know, I'm afraid I don't know the answer to that. I'm the clue. I'm going to pass. If anybody else has got any ideas how we would do that, perhaps Niti does.
Jamie, I'll not even try to talk about what LCI would do in a situation, but probably because we have a similar rule where we say that the parties can nominate, but it is the council which appoints it. So I think a very narrow distinction there, where we let the parties nominate an arbitrator. And just like LCIA, we do not have a published panel of arbitrators. So parties really have a choice of nomination. But ultimately, once you nominate, it is the Secretariat's responsibility along with the council to make sure that that arbitrator, there is no conflict, and that nominated arbitrator has independence and impartiality, and most importantly, there is availability of time. And when all those boxes are ticked off, the council in most cases and not would actually appoint the same nominated arbitrator. And in any rare case that we may have where the nominated arbitrator does not fulfill the criteria, we would always go back to the parties, nominate somebody else, and then the process follows from there.
I'm gratified to say that that is probably where I would have come out, assuming that that would be the process. I mean, certainly that sounds to me to be the way that we would approach it too.
Okay. There's one question probably will be for all institutions. What percentage of arbitrations in each of the institutions in 2019, 20, and 21 have been virtual only?
Have been, sorry?
Have been virtual only.
Virtual only.
Yes. You want to go, Alex, first?
I'm very sorry, I don't have the figure at the top of my head. I think that with the even that, I think that with the exception of everything that started happening as of March 20, I would say April 2020, nobody was really, at least we were not keeping firm track of the modalities of the hearing itself. We are now in the context of providing that feedback to Icc, because the International Council for Commercial Arbitration is actually conducting research in that regard. And I'll be very happy to share that information once I have it. It is under preparation currently. I would think the number has grown, but it's not really possible to say with absolute numbers where it was before and after.
Niti, would you have any numbers, comments?
All I can say, Raj, is that of course, like I said, we have now 35 cases being administered under MCIA rules. We are pretty new to the system itself. But in 2020 and 21, all our cases that were filed in have only been held virtually. We have not had a single physical hearing being held in India. And at least I would say that we had in 2021, we've had almost about 20 new cases coming in, and 5 of them we've already had an award ready, with 3 of them already delivered, and the entire proceeding right from the notice of arbitration to the final hearing has all happened virtually. So I don't know if that that's the best statistics I can give probably right now on top of my head.
Kevin?
Raj, we actually had a very interesting experience in Singapore in terms of how the COVID-19 pandemic was handled, because we had a mix of fully virtual hearings, hybrid hearings, and then in-person hearings. So we haven't released data as well, but the majority of the hearings were conducted virtually. And I think that this has been such a boon to arbitration. Icc, LCIA, and SIAC, we were one of the 12 institutions that released a joint statement on how we were going to work together to keep resolving disputes. I know for all of the panelists up here today, I would be happy to consult them on any tricky question, whether it relates to virtual hearings or otherwise. But we've also seen how tribunals and parties have adapted to this. We all remember that counsel in April that was saying that they needed to see the whites of a witness's eyes, that it was only going to be the very small value disputes, that would be resolved virtually. But arbitration has taken to it very well. And so now the questions for tribunals we see in SIAC arbitrations is dealing with potential issues of asynchronous hearings. So having to flip the pleading schedule, or asymmetric hearings, where you may have the presiding arbitrator and the co-arbitrator resident in Singapore and able to participate in person, but because of fairness considerations, perhaps the two co-arbitrators participate virtually, even though one is resident in Singapore. So two sets of counsel in Singapore, presiding arbitrator in person, co-arbitrators participating virtually. So for me, when I look at it, I think that virtual hearings have made arbitrations faster, more cost effective, and I think of increasing importance, much greener. So it's been a very good adjustment by arbitration.
Raj, one last point on my side. Yeah, I have the first results that we did, but again, those are empirical. They're not final. Between March 2020 and about the sort of like the beginning of the summer this year, on the basis of what we see in awards and procedural orders, at least, there were about 112 remote hearings, about 28 physical hearings, and about 25 hybrid hearings. But again, those numbers are quite empirical for now, so I wouldn't use them with a lot of allowance. I would suspect, like Kevin has said, that the number of the probably hybrid hearings will be on the rise once the situation stabilizes, and ultimately there are ways in which either a fully asynchronous hearing or segments of an asynchronous hearing can be incorporated into the hearing experience to make everyone's life and pockets a bit easier to handle.
Jamie, your thoughts?
Yeah, I think the same it has to be true in London. I think we don't keep very reliable data. As you know, we don't maintain a close connection with any particular hearing centre, and so it's sometimes quite difficult to track what's been happening. But certainly the move to virtual hearings was very swift, and the amendment to Article 29 of the LCIA rules to provide specifically for virtual hearings on a number of platforms came between the date when the rules were originally to be released in early 2020 and their publication date in October 2020 as a response really to that reality. Anecdotally, what I would say is that the LCIA headquarters have moved in London over the last month, and we remain part of the International Dispute Resolution Centre, which has itself doubled in size and provides facilities for hybrid hearings and for virtual hearings within its facilities. But an awful lot of live hearings are going on. I'm quite surprised every day the number of hearing rooms at the IDRC which are occupied with arbitrations, some mediations, but a lot of international arbitration traffic now seems to be going live again in London. So I wonder if the Kevin's comment about wanting to see the whites of the eyes is going to come back. Personally, I would like to see as much virtual as possible, but anecdotally, I think we're beginning to warm back up again.
I have a very interesting question, and that says that what can be done to ease the understanding of rules of institutions by non-lawyers, promoters, and other clients? Is there a possibility to have some sort of primer or a presentation to navigate them, and if any institution has already done this? Yeah, Jamie, please go ahead.
I'm happy to kick off. I mean, I'm probably, I don't know, I'm probably the one most recently out of private practice on this panel, and I was always amazed that these kind of events, and certainly probably the four of us have a disputes background, and in fact it is really our corporate colleagues, corporate and commercial colleagues, that need this kind of information, and indeed their clients. And it was always an intention of mine to appeal direct to clients and to general counsel, to those who make the deals and negotiate contracts. The corporate lawyers are the ones that put the contracts into words, and I suspect that they are really the people who need to be educated about the benefits of particular institutions. I think fundamentally one of the things that you will all have heard today is the difference in the way that we all charge for our services, and that's quite a fundamental question for many parties, and perhaps not one that is at the forefront of everyone's minds. I'm not sure that any of us want to lead on cost as a benefit, but it is a very important consideration for parties when they're choosing institutions, their ability to consolidate, their ability to, for interim measures and for early determination. That there are similarities, I think, between all of us, but there are some very fundamental differences which might be drawn to the layman's or the non-litigator, the non-arbitrator's attention. And so, yeah, I would be very much in favour of that. It's not something that we are proactively following, but it's certainly something I would advocate.
Any of you, anybody else has a comment? Or
I can very quickly jump in to say that, of course, the ability for us to connect with existing and prospective clients of our respective services is really important. And that goes, of course, to the corporate lawyers within a firm, but also, of course, to the in-house lawyers within the sort of like the potential direct clients as well. As I mentioned earlier, at least on the side of ICC, there is a lot being done in the context of capacity building, education, and learning. So that forms a very core part of who we are and what we do. And I'm very happy to sign up for any of that. Very happy to do so.
Raj, I would just finish with this is really the changing roles of institutions. If you look at all of the institutions on the panel today, institutions are no longer mere stewards of the arbitral process. And as Alex said, there's really a priority on thought leadership, and capacity building is one of the most important things that institutions do. So from SIAC's standpoint, we conduct training in Singapore and countries around the world, university modules, and every institution is doing that. And in fact, you can look at all of the guidance released by the institutions. So the ICC notes, that provides a very good understanding into how the rules are interpreted and how they actually function in practice.
Very quickly, with respect to the MCIA, we conduct something yearly, what we call as a lifeline of an arbitration. It's a 5-series webinar, which we do, and the idea really is to help parties understand that what every particular rule in the MCIA entails, and how is it applied in practice. And I agree with Kevin on that part, that usually the institutions from time to time either conduct events or publish articles and guidance notes, which can be very helpful in understanding the nuances which the institutions have in their application and in the case management.
there's one more question that's come right now is, are arbitral institutions witnessing any arbitrations arising from technology-related contracts, for example, blockchain arbitrations? Which specific areas of technology are most likely to develop as field of institutional arbitration? Kevin, where do you want to go?
We certainly are, and I mean, Singapore is one of the leading hubs in the world for fintech. There's a lot of SIC arbitration clauses in ICOs, and a lot of this goes to the precision and nuance of an institution. You can imagine a situation with cryptocurrency where a party is making an application for expedited procedure on the basis of the sum and dispute. That sum and dispute can change very quickly. Same thing for the calling of deposits. How is an institution going to call for deposits based on the sum and dispute? You will also see the updates to the Singapore legislation on the arbitrability of certain types of IP disputes. I think that arbitration overall needs to cater to these new sectors and really is catering to these new sectors. Same thing with renewables, mining on the moon, as the case may be. For most of these sectors, arbitration still remains the preferred method to resolve them. And we're much more able to adapt to the specific needs of these sectors. And perhaps the most important point here is who is being appointed to decide these disputes. These may not be disputes that can be resolved by a judge that doesn't normally hear cases arising out of this sector. The only element that I would say to potential users, sometimes what we're seeing in these arbitration clauses is very prescriptive qualifications for the arbitrator, both for legal experience and experience in fintech. Sometimes it is difficult for the institutions or the parties to find an arbitrator that will meet all of these qualifications. So you want to be a bit mindful when you're agreeing to these very prescriptive qualifications in the clause. And if the institution is called upon to appoint, each side can make proposals, not agreement proposals, of what qualifications the arbitrator should possess. So it's a huge area for growth for all of the institutions on the panel today.
Thank you, Kevin. Jemmy, one more question for you. Are arbitration institutions like yours likely to adopt and launch online case management programs of their own in the future?
Well, I guess likely is the case. For our own part, we are focusing in the next quarter on rolling out an internal case management system, which is just about ready to go, and has been a massive overhaul for us of our internal processes. I think as far as an external platform is concerned, we've stuck our toe in the water with the amendments, particularly to Article 4 of the LCIA rules, which provides that email is the default means of communication between parties and the Secretariat, and the Secretariat and arbitrators and the parties. As far as an online platform is concerned, candidly, we are exploring that, and I think we're keeping our eye on the experience of others. I see that Hong Kong has just announced their platform. I think it's bound up with some very tricky questions of data privacy and data protection and cyber security. And the feedback that we get, I think, from the London market, from users, and particularly from our user law firms, is that they would need to be convinced of the security of an external platform operated by an institution like the LCIA to convince them to transport their data and their confidential material from their own platform into ours. And that, I think, is something that we need to examine very carefully, and that all institutions will need to be very mindful of.
Okay, I think it certainly has been thought-provoking event. I think, to me, some of the key takeaways have been that every institution that we have today has something unique to offer, and I think that's something that we all should consider. In my view, it's very important that we examine the rules of every institution before we recommend to our clients, or we decide to have an institution's name into the agreement. It's important that the client goes through the rules once. He knows which rules he's choosing, so that it's easier for him to then run through the entire process of arbitration at the end. So it's very important in my mind that happens. The distinguishing features of each of the institutions was really brought out to the forefront because of all of you being there present today, and actually giving us what each of you have to offer and what is the unique part of it. So I think for me, it's very, very important that if anybody also has a query in relation to any rules, to actually reach out to the institution and see if their queries are getting satisfied or they are getting answered. Because it's important that before you put in your clause, you know what you're getting into. I think it's very, very important. And I think some of these questions which we have not been able to take it up and which are still coming in, we'll try to answer them post the webinar, and we'll send the responses to each one of them. Finally, I would like to thank the Icc, LCIA, SIAC and MCIA for agreeing to participate in this webinar, and each of the representatives for being here today and presenting to us. Alexander, Jamie, Kevin, Niti, thank you so much. Without you, this webinar would not have been possible. You each did an outstanding job, and we are very much indebted to you. To our audience, I hope you found the webinar interesting and worthwhile investment of your time. We certainly enjoyed bringing it to you. After the webinar, we will send you a copy of today's presentation material and a link to the webinar recording. We will also separately receive a request of your feedback on the webinar. Please take the time to send us your feedback, comments, criticism, and even compliments. The form takes less than 1 minute to complete. Please do not hesitate to contact us regarding any matters arising from this webinar. Our contact information is on the contact slide at the end of the webinar. Thank you for your attendance today, and we look forward to bringing you more webinars in the future. Thank you, all of you. Thank you.
Thank you, Raj. Thank you very much.
Thank you. Thank you all.
Raj,
Thank you.
thanks everyone.
Thank you.